Um, the reality is that from an employee handbook perspective, most states out there, every employee that you have is an at-will employee. That means, and it sounds a little crass to say it, the church can terminate at any time and the employee can terminate at any time. What it basically means is there's no contract. There's no contract that says you're going to be employed for X amount of time. And if you're fired, here's what the church has to do. Well, what sometimes becomes confusing about employee handbooks is that we don't want them to be a contract. What the courts and different lawsuits have fought about for a long time have to do with whether or not certain employee handbooks become contracts. And that's where, again, that kind of Frankenstein example of putting an employee handbook in place that you've gotten from somewhere else without having a lawyer take a look at that language or without really going through it with a fine-tooth comb, what ends up happening is you may be unknowingly creating provisions that actually the court has adjudicated, or adjudicated means decided, are contractual provisions that actually make that employee's role at that organization a contract versus at will.